फ्रेंड्स, आज 21 मई, आज के इस लेक्चर में हम बात करेंगे फैमिली पेंशन की। पेंशन एम्प्लॉय को रिटायरमेंट के बाद मिलती है जब तक कि उसकी डेथ नहीं हो जाती, और वो होती है उसकी लास्ट ड्रॉन सैलरी का 50%। और यदि वो कम्यूट करा लेगा तो फिर मिलेगी उसको 15 साल तक अनकम्यूटेड पेंशन, और 15 साल के बाद वो दोबारा रिवाइव हो जाती है। एम्प्लॉय की डेथ होने के बाद फिर मिलती है फैमिली पेंशन, और वो होती है 30% ऑफ द लॉस्ट ड्रॉन सैलरी ऑफ द एम्प्लॉय। और यदि आप कम्यूट करा लें तब भी उस पर कोई फर्क नहीं पड़ता। फैमिली पेंशन रिमेन अनचेंज्ड। फैमिली पेंशन कोई खैरात नहीं है, ये गवर्नमेंट को देनी होती है जहां पर एप्लीकेबल है। फैमिली पेंशन सिर्फ इमीडिएट फैमिली के लिए नहीं है कि वो सिर्फ वाइफ या हस्बैंड या बच्चों तक सीमित रह जाती है। फैमिली पेंशन में स्पाउस आता है, उसको तब तक मिलती है जब तक वो रीमैरिज ना कर ले, चाहे वो अर्निंग हो या नॉन अर्निंग हो, इससे कोई फर्क नहीं पड़ता। यदि स्पाउस शादी कर ले तो फैमिली पेंशन बंद हो जाती है। फैमिली पेंशन इनकम टैक्स में इनकम फ्रॉम अदर सोर्सेज में टैक्सेबल होती है, और उसमें एक स्टैंडर्ड डिडक्शन मिलती है 1/3 और 15,000 whichever is lower। स्पाउस नहीं है तो फिर बच्चों को मिलेगी, और सबसे पहले उस बच्चे को मिलेगी जो 25 साल का नहीं हुआ और जो सबसे बड़ा है। जब वो 25 साल का बड़ा हो जाएगा फिर नीचे वाले का नंबर आ जाएगा, फिर उससे नीचे वाले का आ जाएगा। उसमें कंडीशंस हैं कि बच्चों को कब तक मिलेगी। अनमैरिड सन को या तो 25 साल की एज पूरी कर ले तो बंद हो जाएगी, शादी हो जाएगा तो बंद हो जाएगी, और कमाना शुरू कर दिया तब बंद हो जाएगी। तीनों में से कोई भी ओकेजन पहले हो गया, अनमैरिड सन की पेंशन बंद हो जाती है। यदि स्पाउस की डेथ हो गई, अब जो लिविंग स्पाउस है जो फैमिली पेंशन ले रहा है उसने कोई बच्चा अडॉप्ट कर लिया, तो फिर जब इस विडो की डेथ होगी तो उस अडॉप्टेड चाइल्ड को फैमिली पेंशन मिलने वाली नहीं है, क्योंकि जब ये बच्चा अडॉप्ट हुआ तो वो सज्जन जिंदा नहीं थे। जी हाँ, यदि लड़का या लड़की डिसेबिलिटी के शिकार हैं, इसमें ब्रदर सिस्टर भी आ जाते हैं, डिपेंडेंट वाले, ता उम्र मिलती है, ता उम्र लाइफ टाइम। फैमिली पेंशन में अनमैरिड डॉटर, विडो डॉटर, डिवोर्स्ड डॉटर भी आती है, लेकिन उनकी यदि इनकम हो गई तो फिर फैमिली पेंशन उनको नहीं मिलेगी। ब्रदर सिस्टर्स में डिपेंडेंसी का रूल है, जो डिपेंडेंट हो और डिसेबिलिटी के शिकार हो उनको मिल जाएगी। इसके बाद कैटेगरी आती है पेरेंट्स। पेरेंट्स के केस में वो पहले तो डिपेंडेंट होने चाहिए, और ये हायरार्की चलती है। पहले स्पाउस का हो गया, फिर चिल्ड्रन का हो गया, सन्स का हो गया, डॉटर का हो गया, उनके हैंडीकैप वाली बात हो गई, डिसेबिलिटी वाली बात हो गई, लास्ट में आता है फिर पेरेंट्स। पेरेंट्स डिपेंडेंट तो होने चाहिए। अब उसमें माँ को मिलेगी, बाप को मिलेगी, तो रूल कहता है पहले माँ को दो, बाप को बाद में मिलेगी। यदि स्पाउस को कोई फैमिली पेंशन वाला है, अब एक तरफ तो फैमिली पेंशन लेके जिक्र में उसने मर्डर ऑर्डर कर दिया, तो फिर उसको फैमिली पेंशन नहीं मिलेगी कि आपने खुद ही जानबूझकर उसका मर्डर कर दिया कि आप फैमिली पेंशन के हकदार हो, फिर आप फैमिली पेंशन ले लो। ऐसा नहीं होगा। लेकिन मान लीजिए एम्प्लॉय की डेथ हो गई, उसके स्पाउस भी नहीं है, उसके बच्चे भी नहीं है, उसने शादी की नहीं, उसके भाई जो हैं वो अडल्ट है, पेरेंट्स भी नहीं है, तब क्या हो? ऐसे केस में पेंशन, फैमिली पेंशन तो नहीं मिलेगी, लेकिन यदि पेंशन है तो जब तक वो जिंदा थे व्यक्ति को मिलेंगे जो उनका सक्सेशन सर्टिफिकेट लेकर सक्सेसर बन जाए। एनसी बख्शी जिन्होंने केस किया था 2010 में, उनकी डेथ हो गई जनवरी 2019 में। अब उनके भाई साहब हैं, बस घर में ना पेरेंट्स हैं, शादी उन्होंने की नहीं, बच्चे हैं नहीं, तो ब्रदर को फैमिली पेंशन नहीं मिलेगी। ब्रदर को फैमिली पेंशन कब मिलती, सिस्टर को कब मिलती? जब वो डिपेंडेंट हो और हैंडीकैप वाली कैटेगरी में आते तब मिलती। अदरवाइज इनके भाई साहब को, ऐसी बख्शी साहब को फैमिली पेंशन तो नहीं मिलेगी, लेकिन पेंशन के एरियर्स 2010 से लेकर 2019 तक जरूर मिलेंगे, जब उनकी डेथ हुई 23 जनवरी 19। लक्ष्मी कॉलेज का एक केस था, उसमें वाइफ की डेथ हो गई। अब उनके जो हस्बैंड हैं उनको जो उनके पेंशन जो है टिल डेथ वो तो मिलेगी, और उनकी डेथ के बाद वो जो मिलेगी वो फैमिली पेंशन कराएगी। अब मैं आपको इस टाइम एक बात और बता दूं कि जो पेंशन मिलेगी ना, इसको आप इनकम टैक्स में बाइफरकेट कर सकते हैं ईयर वाइज, सेक्शन 89। फैमिली पेंशन को भी कर सकते हैं। ऐसे केस में आपको जो पेंशन का एरियर्स क्लेम करना है तो उसके लिए सक्सेशन सर्टिफिकेट तो लेना होगा। वो किस लिए? जिससे कॉलेज को ऐसा लगे कि अभी तो हमने इनको दे दिया अस्सी बख्शी साहब को, आपको 15 दिन कहना, 20 दिन कहना, 1 साल के बाद कोई और आ जाएगा। तो कोर्ट कहती है, कोर्ट से सक्सेशन सर्टिफिकेट मिलता है वो आपको जमा करो, फिर कॉलेज कोई ऑब्जेक्शन नहीं करेगा और आपके खाते में पेमेंट डाल देगा। लेकिन इसका टैक्स कौन देगा? इसका टैक्स तो वही देगा व्यक्ति जिसकी पेंशन थी। वो आप डिफरेंट ईयर्स में इसका बाइफरकेशन करके फायदा भी उठा सकते हैं, लेकिन थोड़ा टेक्निस्ट काम। और देखो, पेंशन या फैमिली पेंशन दोनों ही राइट हैं। ये कोई ऐसा नहीं है कोई आप पर एहसान कर रहा है। अब हम गुप्ताई से फैमिली पेंशन के बारे में वो जो उनके व्यूज हैं कोशिश करते हैं।
फैमिली पेंशन is a welfare scheme framed to provide relief to the widow, spouse, cases children, parents, and other relatives. Not provide for nomination in case of family pension. Instead, the rules designate certain persons who are entitled for family pension. For grant of family pension, the family includes spouse, children, parents, and disabled siblings. However, their eligibility to receive family pension will be governed by orders issued from time to time by the government. As far as eligibility of a spouse is concerned, family pension is payable to widow or widower up to the death or remarriage, whichever is earlier. I repeat it, and this is something very important. Family pension is payable to widow or widower up to the date of death or remarriage of the person receiving pension. The family pension will continue to be payable to a childless widow on remarriage if her income from all other sources is less than the amount of minimum family pension and the dearness relief admissible. So, a general belief in the society is that if the widow of a person who has expired, she remarries, then she is not entitled to family pension. But what I am submitting here is that if her income from all other sources is less than the amount which she would be entitled to get as family pension, then even after her marriage, remarriage, she will be entitled to family pension. The children shall be payable in order of their birth. This is something very interesting. And the younger of them will not be eligible for family pension unless the elder next above him or has become ineligible for grant of pension. So this will be a hierarchy even among the children. Where the family pension is payable to twins, there may be a case where they are twins. It shall be paid to such children on equal basis. In an unmarried son, family pension will be payable until he attains the age of 25 years, or he gets married, or he starts earning. There are three things, whichever is earliest. That is, a son will be entitled to family pension if he attains the age of 25 years, if he starts earning, and if he is married, whichever is earlier. And then after that, he will stop receiving family pension. By the spouse of the petitioner shall not be treated as member of the family. This is the point to be uh, concerned. Of a government servant is suffering from any disability or physical, then he or she may be entitled to receive family pension for life. The family pension is payable to the disabled children for life after the youngest child attains 25 years. Their pension shall be resumed in favor of the child suffering from disability. The child who is entitled to get family pension is a minor. Then it has to be through a guardian, because a minor is not eligible to get anything. He is not eligible to enter into an agreement, a contract, and therefore a guardian is necessary in case of a minor entitled to get family pension. They allow continuance of family pension to mentally, physically disabled children even after age. This is the point to be noted carefully. Just now we had referred to a case where a son will stop getting family pension after his marriage. But if it is a case of a physically or mentally disabled child, then he will continue receiving pension even after marriage. I will just briefly refer to certain other important aspects of this. That is pension claim if the government servant has survived by widow or children, the divorce proceedings as per custom or community or before the panchayat is not a valid proof of marriage. The divorce decree is acceptable only if it is ordered by a competent court. Friends, in 11 of the Hindu Marriage Act, any marriage shall be null and void if the party has a spouse living at the time of marriage. This is understood very carefully. However, if employee is survived by one widow and children from first wife. Please note it carefully. If the deceased employee is survived by one widow and children from his earlier wife, who is no more, then in that case, the distribution will be 50% each to the wife, the current wife, the second wife, and the children of the first wife. In case of divorce, if the first wife was divorced, then again a similar situation will arise where the wife will get 50% and the children of the second wife, children of the first wife will get 50% of the family pension amount. If deceased employed by more than one widow, it is possible in some cases, then the first wife and children from the second wedlock, they will get 50% each. So in either of these cases, what are these cases? The first wife is dead, where the first wife is divorced, or in case of more than one wife, the first wife will have title to receive 50% of the family pension and the other 50% will go to the children of the other wife. On death of wedded wife who is not survived eligible child, share of the family pension would not lapse but would be payable to the children from the second wedlock in full, that is 100%. Let me clarify it. On the death of wedded wife who is not survived by any eligible child, that is, the wife is not there, the earlier wife, and the children are also not there, then the share of the pension would not lapse, but the children of the will be eligible for receiving 100% of the family pension. Friends, now just have a brief reference to the husband and wife relationship where there is a judicial separation. That is, they are not divorced, but there is judicial separation. Under Hindu Marriage Act, there is a provision that before divorce, on similar grounds, either of the spouse pray before the court for judicial separation. The wife is entitled to get family pension. Now, of parents, family pension to the people if the on the government servant. This is first, and the deceased government servant is not survived by a widow or eligible child. These two conditions are to be carefully noted. But in case of the mother will have priority over father, mother will be eligible to pension. And in case she is not interested or she is no more, then in case the father is entitled. And parents are entitled to receive family pension for their whole life. That is the point to be understood here. The family pension is not admissible. If a person for murder or abetting murder of the government servant, there may be a situation like that. That is the person against whom the family pension is claimed, and the person claiming it is himself responsible for murder of that person or abetting murder of that person, then such a person shall be debarred from receiving the family pension. The family pension shall be payable to next eligible member of the family. Now, friends, I will be talking about the two cases cited by S.B. Rathod. Just a brief reference to some of the decided cases. That is, a very of right to is violation of Article 21 of the Constitution of India. This provides every person, not only citizen, every person, a right to life and personal liberty. And family pension is also akin to the right to life, personal liberty, and therefore family pension cannot be denied to the eligible because, as I had pointed out earlier, it is a welfare scheme framed to provide relief to the family members of the person who is no more. Reference a case which is quite interesting. There was one Mr. Bhola, it may be any name, but here in this case it was Bhola, being granted family pension in respect of his wife, Ramrati. He raped his own daughter and was convicted under 376 of the Indian Penal Code. Section 376 provides for rigorous imprisonment of not less than 10 years, and the court may impose fine also. And this man was convicted for 10 years, completed the sentence of 10 years, and the court fined him 10,000 rupees, and that was also paid by him. And thereafter, he claimed family pension. He pointed out that whatever wrong he had committed, he was punished, already punished, sentence was there, everything is over, and now he was entitled to. Now think, pause for a minute, whether such a person is entitled to receive family pension. I wish to point out a very interesting CCS Pension Rules 1972, which provides that pension is subject to future good conduct of the pensioner. The person getting pension, if he satisfies the court that he will take all precautions, he will take all care for a good conduct, then pension may be given to him. Now, going to Professor N.C. Bakshi's case, who was the leading petitioner in category 1 cases, that is N.C. Bakshi versus Delhi University and others. He expired when the case was SLP stage before, but otherwise he was there for about 10 years of filing the original petition before Delhi High Court. He did not have wife, he did not have, his parents are also no more. And just now I refer to all these persons. The question is then who will be entitled to family pension in such cases or receiving the dues in such cases? Here I wish to draw attention to Section 380 of the Indian 1725. This is the law which provides for grant of succession certificate. And this succession certificate is conclusive evidence that the person producing that certificate and after getting it from the court claiming the amounts of the person who is no more. Who can apply for succession certificate? There are certain conditions that the person must be of sound mind. He must be major, not minor. Person having interest in the estate of the deceased, he has to show as to how he or she is in the property of the deceased or claims of the deceased. In this case, late Professor N.C. Bakshi. The district judge of the area where the deceased used to live. Details of properties, whatever are available up to that time, are to be disclosed. And it is also be disclosed as to who are the other probable claimants of the, in this case, pension, pension rights, arrears, family pension, whatever. This petition is to be verified by the person who is approaching the court for a succession certificate. Here, right of petitioner, that is how he is entitled or she is entitled to receive the money which were due to the deceased professor. This certificate, district judge, after satisfying himself that here are the genuine claimants, during this satisfaction for the honorable district judge, an order may be issued to give a public notice कि भाई ये लोग हमारे सामने 2 या 3 लोग आए हुए हैं, they are asking for a succession certificate. If in this world there is anybody else also, any relative, any close relative, anything, any friend, then he or she may also file claim before the, and the certificate will be issued after full satisfaction of the, that under the circumstance, the petitioner is the right person to whom the money's dues may be given. In this case, in the present case, who will get the money? And what is the money? That is the pension amount till the death of Professor Bakshi. Number 2, the arrear amount, interest, if any, And other properties may also be mentioned while asking for succession certificate from the court. Now, it has to be understood because I am referring to a few cases. That is, the person getting has a title to the money dues from anybody. That is, in this particular case, the money is to be taken from the university and the college concerned. But this is decided. Money is to be received from the university or college is not a matter to be decided by the Honorable District Judge. He will simply decide who are the persons eligible to get that money. That is the point to be understood. How much money is to be claimed, how much money is permissible, that is not the job of the district judge while considering the petition for grant of succession certificate. And after this certificate is granted, evidence that the person will get it. And it will be an indemnity against the persons in favor of the persons releasing the money. Later on, if anybody else appears, let us say after 2 years, 3 years, 5 years, that he or she was entitled, was the rightful claimant, then the university or college or any employer, then he can show that here is a succession certificate issued by a court of competent jurisdiction, and on good faith, the money was released. And therefore, the employer will not be responsible. Now, one last comment before I talk about the specific case: distinction between succession certificate and will. If will is there of any person, then decided by the provisions of the will. That is, it was self-acquired property of the deceased, and whatever he has written in the will, to whomever he wanted to give his property, he or she will be entitled to that. But if the will is not there, then succession certificate is a valid document. And in most of the cases that I have dealt with, I have seen that the court prefers that even if there is a will, let the copy of the will be also produced at the time of praying for succession certificate. So we normally do it in the court. That is, my lord, here is the will, and according to this will, I am entitled. You kindly verify and then pass an appropriate order, and the court does that. Now, coming to the very specific case, as Dr. Rathor pointed out, NC Bakshi, unfortunately, he did not have wife run parents. In this case, particular case, any other relative, maybe brother of NC Bakshi, or any other relative who feels that he or she is entitled to get the money due, the pension and area, etc., may approach the district court. In this particular case, I have come to know the family members, the brother. Uh, we have got the permission to state the name also, as Dr. Rathor was pointing out. A brother who is elder to NC Bakshi desires to claim whatever amounts are due. Now, our suggestion is that in this case, the college or university will not allow unless there is a succession certificate or unless there is a will. In all probability, as per our information, the will is not. If it is there, then the provisions of will apply. Then the family members, the brother, and whosoever wants to approach, he has to approach the district judge of the place of the court, district court, where Professor Bakshi used to live. And after satisfying itself, the court will issue a succession certificate. And then an application may be made to the principal of the college and to the university for release of that money. And that may be released. And after it is released, then nobody can claim later on that he or she was entitled. They may fight, they may have a claim against each other. The person who was getting money and the person who claims later on to get money, his entitlement. But the university or college will not be responsible, as succession certificate is conclusive evidence of the right. Now, coming to the second case, as Dr. Rathor pointed out, degree 2 case where the wife expired and the husband is getting claiming family pension. Now, he has a family pension, and till the date of death of the wife, he is entitled to get arrears of whatever pension amount is there, and after that he can claim. And in case there is anybody else who desires to claim has to place his or her claim before the college authorities. And here in this case, because the husband is there, succession certificate is not. In a nutshell, I have and the position in these two cases, which are specifically there before us. One belongs to category 1, the other belongs to category 2, and we have absolutely no prejudice against any category. We are talking about the general rights of the members of